Major breaking news. We have a huge potential case to establish excellent precedent for the Second Amendment out of the federal courts in California. A case involving Byrna Technologies, the publicly traded company of, guess what, non-lethal arms, has just sued challenging California's ban on so-called pepper projectile launchers. This is an excellent complaint with very good information in it. Sounds like it tracks a lot of the Four Boxes Diner teachings, and there's some ways to improve it, but we're going to talk all about this exciting lawsuit with huge potential and great implications for our Second Amendment rights when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. And you know what I'm going to say? I have been nominated again in the category of top voice of the Second Amendment, top voices, the 2A, for the 2026 Gundies Awards, to be awarded at the end of January 2026 out there in Las Vegas, right before the SHOT Show. And I want to remind all of you, to the extent you're willing to go to thegundies.com and vote, please vote for Mark Smith, Four Boxes Diner, in the top voices of the 2A category. It's stiff competition. It's always tough to repeat, but I think we can. I think we can get them. I think we can repeat. Fingers crossed. Candles lit. All right, folks. So this is exciting news. An excellent complaint has been filed in federal court in the United States District Court for the Southern District of California. This is a case involving the publicly traded company Byrna Technologies, which is the company that specializes in selling so-called non-lethal arms, sometimes referred to as pepper projectile launchers, along with these sort of devices, I should say, the ammo that goes along with it. We don't need to break down the technology just yet. We can get to that in a moment. But this is a hugely important case, folks, because it should be a case that gives rise to very favorable precedent in favor of the right to keep and bear arms, the right to acquire arms, and our Second Amendment. Specifically, this is a challenge to California's ban on these so-called pepper projectile launchers that fire sort of non-lethal rounds. I view these weapons that Byrna Technology produces, you can disagree if you want, but I view them to some degree as a gateway weapon for those people that are scared or nervous with firearms, or for some reason cannot possess firearms for one reason or another. This is sort of a halfway point where people can acquire these non-lethal weapons that are sufficient to engage people and function in an effective self-defense scenario to protect yourself and your life, the lives of your loved ones, and so on, without basically using firearms. There is certainly a large market for this kind of non-lethal technology. I suspect that a lot of young women who lack familiarity with actual firearms would look for an alternative to protect themselves from the predators, creeps, gangsters, cartel members, and other nut jobs that we either have here in the country or we have imported thanks to the open border policy of Joe Biden and the Democrats. So with this said, this is a lawsuit that is very powerful. The complaint is very well done. It makes excellent points. There's one minor modification I'll flag at the end here, but it's very minor. It can be dealt with later on. It's not a mistake. It's just a slight room for improvement and thoughts. But the bottom line is this is an excellent vehicle because I think it's going to be very difficult for even the California courts and the U.S. Court of Appeals for the Ninth Circuit there in San Francisco to somehow find that California's ban on these non-lethal arms is somehow constitutional under the Supreme Court precedent of the Second Amendment. So to begin with, here is the essence of the complaint. This is the introduction of this lawsuit brought by several individuals that want to acquire Byrna Technology weapons, and also Byrna Technologies itself is a plaintiff in this case. Here's their introduction right here. The Second Amendment protects law-abiding citizens' rights to possess and as an incident to acquire arms for lawful purposes, including self-defense. Plaintiffs bring this lawsuit to challenge California's ban on the possession and sale of pepper projectile launchers. Pepper projectile launchers are a commonly used arm that many Americans choose as a non-lethal alternative to firearms. California does not just deny its citizens this choice. It criminalizes the act of selling or possessing such an arm. This inexplicable ban violates the Second Amendment. In Catano versus Massachusetts, a unanimous Supreme Court held that non-lethal stun guns are quote-unquote arms protected by the Second Amendment. the non-lethal arms at issue here are similarly protected. Yeah, I agree. This really should be a no-brainer case. Under the standard of dangerous and unusual, which is the historical tradition, I don't see how these arms can be defined as dangerous because, as you know, a dangerous and unusual weapon doesn't just mean it's dangerous, because all weapons are by definition dangerous. So it has to be at least some sort of unreasonably dangerous standard, which there's no way a non-lethal weapon like this burn technology pepper firing weapon can constitute. Nor can it be unusual, because, of course, there's well over 1 million of these things, at least in the United States. And here is where I might make a slight tweak to the complaint. Again, it's not a mistake or anything like that. It's just something to keep in mind as the plaintiffs litigate this case moving forward on motions to dismiss or summary judgment, whatever it is. And that is because the dangerous and unusual standard, which is the applicable standard for determining whether a modern gun ban is constitutional, that arises from the historical tradition of firearms regulation. As a consequence, the burden is on the government to demonstrate that an arm they're trying to ban or otherwise regulate is dangerous and unusual, meaning the government bears the burden to show that a particular arm, in this case, the pepper projecting or the pepper firing projectile launchers here, that they are dangerous and unusual, and that is the burden on the government to demonstrate they're dangerous and unusual. And I don't see any way, shape, or how that the California state government can somehow establish and meet their burden that these arms are dangerous and unusual. And again, I think it's a critical reminder when you litigate these cases over arms that at the end of the day, under Supreme Court precedent, the burden is actually not on the Second Amendment rights claimants. In this case, the individual plaintiffs of Sandy Schiller and Lucas Alonzo Martinez and Byrna Technologies. The burden is not actually on them to show that these weapons are not dangerous and unusual. The burden is actually on the government to demonstrate that they are dangerous and unusual. So I always like to remind people engaged in these litigations that, yes, put on the evidence that shows that your arms are not dangerous and unusual, but never forget that the burden is on the government, and always remind the court over and over and over again that that is where the burden lies, on the government and not on the Second Amendment rights claimants. And again, I do think this is the next complaint. One of the things they do nicely is to explain the technology of these arms. Here is how they explain these particular arms, or these pepper launchers, if you will. Unlike conventional firearms, pepper projectile launchers function exclusively using standard CO2 cartridges or other compressed gases containing no gunpowder or explosive mechanism whatsoever. The launcher's primary defensive purpose and function, as it is commonly sold and understood, is to deliver irritant projectiles to temporarily incapacitate an aggressor. The launchers that Byrna offers to civilians are manually operated, requiring a separate trigger pull for each projectile fired, and the magazine for the most popular civilian model holds only 5 projectiles. Mechanically, these features position pepper projectile launchers alongside recreational handball and airsoft markers, not firearms. Roughly 90% of the launchers Byrna sells are pistols, and rifles constitute the remaining 10%. I think that's a very helpful description of the technology, but the big thing is we know that arms, meaning firearms, are protected on the Second Amendment. I know there's some debate about aspects of that, only because you have these rogue anti-gun courts in places like California and the blue states are trying to pretend that Supreme Court precedent doesn't exist and the Second Amendment does not mean what it says. But I think that's going to get resolved in the next 18 months by the Supreme Court in one of those AR-15 cases. I suspect the Barnett case out of the U.S. Court of Appeals for the Seventh Circuit, but then I digress. So the point is that it's going to be very difficult for even the California federal courts to somehow rule against the plaintiffs in this case, given these are really non-lethal weapons. But it gets better, and again, I think this is an excellent complaint. I think they made some great points, and one of the nice points they make here is the theme, and this is, they don't use the word in this complaint that I caught, but it's a theme, and the theme they're driving home is that this California law that outlaws this kind of technology, these kinds of non-lethal arms, that these laws, or this particular law, is undeniably an outlier law. An outlier law. That's right. This is a very big inside baseball thing to understand at the Supreme Court. If you talk to the justices, I think they basically would acknowledge this, and that is that they don't like to see these kind of outlier laws. For example, this term, the Supreme Court is going to rule in favor of the Second Amendment, in my view, in that Wolford versus Hawaii case dealing with that insane outlier law, the so-called vampire rule that says you cannot bring a firearm into a privately owned place, even if that privately owned place is open to the public, like a convenience store, a grocery store, a gas station, without first getting express consent from the owner of these places to bring your gun in, even if you have a concealed carry permit. That is clearly an outlier law that right now, as far as I know, is only in effect right now. In Hawaii, for example, the Supreme Court took the Wolford case and they're going to take that nail and they're going to hammer it down and get rid of that outlier law. So I think it's a very smart strategy by the plaintiffs in this case, including Byrna Technologies, which is a publicly traded company, by the way. I think it's a very smart approach for the lawyers in this case to essentially try to establish that this California law is an outlier law, and they do a nice job here. Here are some of the points they make, pointing out that this technology is perfectly legal in 48. That's 48 states right now. There's only issues in California and I think in New York. And they do a nice job pointing out that not only do ordinary Americans own these weapons, but so does law enforcement, and that you can acquire these things from ordinary consumer and retailers like Amazon.com, Sportsman Warehouse, and Bass Pro Shops. Here's how the complaint lays it out, which I think does a great job showing that this California law is an outlier law, and the U.S. Supreme Court does not like insane outlier laws in any area of American jurisprudence, including but not limited to the Second Amendment. Check out what they say in the complaint. Pepper projectile products are widely stocked by mainstream retailers. They are available in brick-and-mortar stores such as Sportsman's Warehouse and Bass Pro Shops, through major online marketplaces like Amazon.com, and from thousands of independent self-defense stores nationwide. In addition, many thousands of law enforcement officers, including the Los Angeles Police Department, Los Angeles County Sheriff's Department, and several other California agencies, use pepper projectile launchers. Pepper projectile launchers are likewise carried as a non-lethal arm by private security personnel. The widespread availability and adoption of pepper projectile launchers for lawful purposes is a nationwide phenomenon. In 48 states, that's 48 states, including jurisdictions with some of the nation's strictest weapons laws, law-abiding citizens may lawfully purchase and possess them. California and New York are the only states that criminalize these common defensive tools for ordinary citizens. I think that's great stuff. I think that's very persuasive. Again, legally, it's not super significant, but in terms of creating the proper gestalt in which this fight will occur, I think it's a great look and feel, sets the proper tone and the proper perspective for the federal judges to take a look at this and be like, why is California doing this? Other than they're insane, which I think everyone understands. That's just the reality of the policies out there. With that said, if you look very nicely at the claim for relief here based on the Second Amendment, they do a very nice job laying out the law. They point out that under the Second Amendment's plain text, the right of the people to keep and bear arms shall not be infringed. The definition of arm encompasses all things that can be used offensively or defensively, and that certainly includes all things that are bearable arms, meaning arms that you're capable of carrying. So obviously, if it's a rifle sized or if it's a handgun sized arm, which these Byrna technology weapons allegedly are, that obviously is bearable arms because you can carry these things readily, and because it's a bearable arm, it falls squarely within the plain text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. And then this complaint does a nice job of pointing out some excellent language that I'm trying to also bring more and more to the fore, and that is some excellent language in the United States versus Rahimi case, that U.S. Supreme Court case dealing with prohibited people under 18 U.S.C. 922G. Specifically, they use the language talking about bearable arms-bearing conduct. This is specifically the quote in this complaint, but they get that quote from the Supreme Court's decision in Rahimi, and it's a very important one for all of you to remember and use moving forward. Here's the quote from this Rahimi case by the Supreme Court, quoted by this complaint in Schiller versus Rob Bonta. When the government regulates arms-bearing conduct, it bears the burden to justify the regulation. Exactly right. And if you want to possess a Byrna technology arm that is arms-bearing conduct, it falls squarely within the plain text. The reason why that's important is that this California law implicates the plain text of the Second Amendment. That means the burden shifts to the government to show a long-standing historical tradition of firearms regulation that is somewhat analogous to this particular current modern-day gun control law, and they're not going to be able to do this. The only standard that has arisen, and the U.S. Supreme Court has already determined this, and that is the only type of regulation in terms of an arms ban case, which we saw in Heller in 2008, is that if an arm is dangerous and unusual, it can be banned provided that the government can establish that that arm is dangerous and unusual. I did a 40-minute video on the meaning of dangerous and unusual. We don't need to belabor the point here because there's very little doubt in my mind that these non-lethal arms are obviously bearable arms, plain textually, and that the historical tradition of firearms regulation level of the analysis, I don't see how the government is going to be able to show that these are dangerous arms as that term is understood in the context of dangerous and unusual, because it can't just be dangerous weapons, because all weapons are dangerous, and if you interpret a weapon as dangerous and dangerousness to mean any weapon, you render nugatory one of the terms that violates basic construction of American law. So therefore a dangerous weapon is by definition, well, it's a tautology in a sense, right? It means the same thing because a weapon is by definition dangerous. So I don't see how they're going to be able to show this is a dangerous weapon for the purposes of the dangerous and unusual test. And obviously I don't see how they can show it's unusual given the fact that there's over 1 million of these sort of pepper projectile weapons out there, these pepper projectile launchers out there. It's a publicly traded company. It's sold in 48 states perfectly legally. It's sold in all the usual retail outlets and vehicles. So I think there's an excellent chance this could give rise to a very big Second Amendment win for Burnett Technologies, Sandy Schiller, and Lucas Alonso Martinez out there in the federal court in the Southern District of California. And we'll keep you apprised as this case moves forward. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxofdiner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.